Matter is DeLucia versus the state, and once again, we will take the appearances of counsel, beginning with counsel for the appellant.
Good morning, Your Honor. Attorney Robert C. Brown for Michael DeLucia, Pat DeLucia, Ann Brown, and Robert Brown. So basically, the attorney and actually the pro se.
All right. And for the respondent.
Diane Whedon, Your Honor, Deputy Attorney General, representing the state respondents.
All right, very good. Mr. Brown, you may proceed.
Thank you, Your Honor. I'd like to reserve a little bit of rebuttal time if required by the court. Based on the different disability acts, because I am a disability retired police officer, and I'm asking for a little consideration on the time on the American Disability Act, Law Against Discrimination, Rehab Act of 1973, and the amended American Disability Act, which is the ADA. So I'm just looking for a little bit of leniency, a little bit of time. I mean, I know usually you get 10 minutes and then 5 for reserve.
Well, let's see how it goes. We've read the briefs, of course, and looking for your most focused argument. Go ahead.
Okay, thank you, Your Honor. 2 weeks ago, Governor Christie indicated the state of the state is good and getting better, but not for the disability retired police officers that are in the case here. These officers were shot in the line of duty. They had their cost of living adjustments to the blood-stained retirement allowances that they received legislatively hijacked and forever suspended in their lifetimes. Some 28 to 25 years later, after they had already been retired. They did their job, Your Honor. They were promised by the state of New Jersey a sound actuarial basis pension, which hasn't occurred. The state has missed their opportunity of proper funding, way too many holidays, they indicated in my brief. In fact, Your Honor, when Governor Christie signed this law into effect in 2011, I took out $1. $2011, put it underneath my bed. Waiting to see when I'm going to get a cold. I wake up today, Your Honor, it's worth 93 cents. Because we have not received a COLA for well over 31 months, and yet they say it's a temporary fix. It's not, Your Honor, it's a permanent fix. Here's our officers that put their life on the line. You've got officers that are here today, firemen here today, and I'm honored to be in front of them, that put their life on the line for every citizen in the state of New Jersey. Yet, tossed to the side, like we're a business entity. Like, oh yeah, it's a dollar number. Just throw us off to the side. They don't know what it's like to go through the injuries that we have to go through. That's why we raised so many issues here. A little bit different than what we saw in the Bergen and JPM. Specifically, when I went before Judge Hurd was basically subbing for the assignment judge, Jacobson, down there in Trenton. He dismissed the complaint. We really didn't get out of the box, the batter's box, Your Honor, for the baseball term. The adequacy of the allegations, we didn't have to prove the allegations. We didn't even get to discover, let alone pleadings, depositions, etc., from the Division of Pensions, the Violent Crime Commission Board, anything regarding the claim to have a complaint. He tossed us aside. When I tried to explain to the appellants what happened, I felt it was before Pontius Pilate, Your Honor. Barabbas.
Why don't you get to the merits? Because we're concerned about the merits here,
all right,
not really with what happened.
All right. Now the first thing we're talking about is the violent crime and the Bill of Rights for crime victims. That was the main focus of where we went. Judge Hurd said he did not see compensation, which you're entitled to as a victim of a crime, to be compensated whenever possible for your loss. Our loss was our job. The pension system basically replaces that money, replaces the salary, replaces the wages, replaces money that we have lost. Our careers were gone. 13 years, 10 years, they're gone forever as police officers because of the shooting that we were involved in. And the effects of what happened thereafter, Your Honor. We're at the bottom of the bottom on the pension. We are the lowest, probably the lowest that you can find. We've been out 25 some odd years. We need our cost of living. The cost of living is not there. Now, the Judge Hurd basically gave a strict view, didn't look broad, very strict view as to what the word compensation was. Compensation, if you want to say compensation, 2/3 of our annual compensation, that is what we got for accidental disability retirement. Enhanced by the cost of living through the Pension Adjustment Act to keep somehow with the pace of inflation, which at one time, Gerald Ford, the President of the United States, said back in 1974 that inflation was the #1 public enemy. Now, yes, inflation has slowed down. That's fantastic, but the only thing is when it does rise, we're affected by it. We're not getting a full 100% cost of living adjustment. We're only getting 60% of that increase. So we're still falling behind. Add up 25, 28 years, Your Honor, it's just not there. But again, following the ball on compensation wherever possible. We could not go to the VCCB, the Violent Crime Commission Board, because we were getting a wage continuation, we were getting workers' compensation, but then those all ended, and then we retired. So the only thing we had left was our pension, our disability pension. So again, he said, oh, I don't see it. I don't see where the COLA is part of it. But yet the pension has been considered protection against inflation by Justice Coleman. Judge Wallace, in a similar case in Brown v. Township of Old Bridge, said COLA is part of the pension. Just the word pension, it's there. So what we were looking for under the crime victims' Bill of Rights was to be compensated for our loss. Now the loss kicks in because of the loss of the job, but then we're being diminished now in our compensation because of the lack of the COLA. As indicated, if you take a 2011 dollar, it's now worth 93 cents.
I think we understand that.
And the other thing, Your Honor, is that the short-time effect is based on the actuaries, which we indicated in our briefs. Because we're on disability, my lifeline, 67 years old. I'm 59. Mr. DeLuca is 61. We have a short time to look at it. And I don't think we're going to see COLA in our lifetime. Because if you retire for time, you go out the door at 77. Here, we're 10 years short, Your Honor. We need that COLA. The officers that got shot in the line of duty in this case as crime victims need their COLA. And in fact, we presented Judge Hurd with an opportunity for what we call the carve-out section of Section 81. Because, I don't know if the judges realize, but for police and firemen, we don't pay into Social Security. So the only thing left for us at age 65, 66 is Social Security. That's going to be reduced based on federal law. Some retirees, they're likely to get $100 to $200 a month in Social Security. Myself and the other repellent, Mr. DeLucia, you know, we may not get that amount of money. We might even get less on the Social Security. We're just not going to qualify for it. So that's why we asked for a carve-out section. 2 retirees asked for relief, which I think would be equitable and fair to say, listen, we'll take you guys out. You're short-timers anyway. You know, you're not going to live past 67. You got shot in the line of duty. Our stress levels will probably up through the roof. You know, luckily, I went to law school, Your Honor. Not many of retired officers that get shot in the line of duty. Most of them have you know, minimal jobs, or some don't even come out of their house anymore, Your Honor. It's a traumatic event to go through that one should never go through. But the thing is that we looked at it this way, that to carve us out, if possible. Although Judge Hurd looked at it, I remember reading his body language, he said, not going to do it. He basically tossed the whole case away. Now, the other argument, Your Honor, we had on the anti-alienation immunity exemption clause that's built into every retirement system. It's basically the same going into a yogurt shop and getting a Neapolitan yogurt, frozen yogurt. You got chocolate, vanilla, strawberry, representing your pension, annuity, and COLA, all swirled into a cup. It all comes in the same check, Your Honor. Now, all of a sudden, the state decides, well, we're going to go back in here, we're going to pull back on the chocolate, which would represent the COLA. Hey, wait a minute, I paid for a frozen yogurt. Well, you're going to get less. Why am I getting less? Well, because you know what? We're short on cash, so we're going to pull back a little bit. That's basically what they did, Your Honor. And they dipped into the funds. There's 5 funds to the police and fire retirement system. One of them represents the part that's pre-funded for the COLA for the next 30 years, starting in 1989. And I know the state had made arguments on that, but again, we didn't get an opportunity to go through discovery to show through the Division of Pensions how those fundings work, how those funds are protected. Now, take for an example, $30,000 retirement allowance, $20,000 being in pension, $10,000 in COLA. The state's argument would be, you know what, you're protected for the first 20, but that other 10 in COLA, well, too bad if you get sued, because that money is going to be attached to a creditor or levy. We're also
isn't there a real argument? Is you're entitled to the 20, you're entitled to the 10,
and
but the 10 is not going to increase.
No, well, that's what they're doing, they're saying.
And you're saying that needs to increase because
That needs to increase.
that's what guarantees essentially the net present value of your money.
That's correct, Your Honor,
I
because, you know.
think we understand that
Okay,
argument.
thank you. So that'd be really what the focus is of what that statute was. It was not only for the protection against creditors, but really the protection against the state putting their hand in, touching that amount of money, instead of letting it flow to the retiree, like DeLuca and Brown. It didn't happen. They just stopped it. Arbitrarily said, there it is, it stopped, for whatever reason. Now, the other thing that, Your Honor, we also put in there was about the protectable interest, the property interest of the spouse on her coal.
I don't think we need to hear additional argument about that because that's essentially dependent on the rest of your argument.
But the one thing, Your Honor, is that I know that Ms. Whedon had a case prior to you in November. And the one thing, I'm not going to quote a lot, but I know equity and fairness was the main buzzwords on the pension matter. That's what the appellants are looking for today. Equity and fairness. We did our time. We paid our money. We suffered. I mean, Your Honor, I set off the alarm with the 2 bullets in my shoulder coming in here. I mean, you know, and then I go on the airplane, I also set it off again. But, you know, that's beside the point.
I think
The injury is there, Your Honor. And, again, they cannot arbitrarily stop that funding. Like I said, picture the yogurt. Picture the yogurt. Swirls, 3 flavors. You just can't segregate one. All 3 come out. You can't stop them.